A very good evening to everyone. Welcome to today's LawWorks Legal Primer webinar on workplace safety, organized by the Law Society Pro Bono Services in collaboration with the National Trades Union Congress NTUC. I am Amira Budiano, your moderator for today's session. So just some housekeeping matters before we get started. Please do not take screenshots or share the materials here without the permission of the organizers. Today, we will be using Pigeonhole Live for our Q&A session, and you can submit questions to the panel of speakers, and you can also upvote on any questions that interest you. If you have a smartphone, a tablet, or a laptop computer with you, just launch your internet browser and enter www.pigeonhole.at into the address bar. Next, key in our event passcode, which is LawWorks, which is in uppercase. Once again, LAWWORKS. Alternatively, you can click on the link shared in the chat function to launch Pigeonhole Live on your device. You may submit your questions at any point during the webinar, and we will strive to address them during or at the Q&A segment. Please note that our discussion and any materials provided are not intended to substitute or constitute professional legal advice. So you should consult a lawyer if you do require specific legal advice. So now let's begin the session proper. Last year, we had a similar session, which you may know about the same topic, which is workplace safety in light of the changing norm. So this year, we are interested to see if anything else has changed, given that the concepts of working from home, hybrid models, and freelancing are here to stay for the long haul. So how then can workplace safety and work injury policies be adapted to meet these varying workplace landscapes? Let me introduce our panel for today first. First, we have Raj Singh Shergill. Raj has been a lawyer for 2 decades and sits on the Law Society Committee for Personal Injury. He is the managing partner of Lee Shergill LLP, a law firm specializing in medical negligence and personal injury. The firm has consistently been recognized as one of Singapore's best law firms in the Straits Times Statistic annual survey and has collaborated with the Law Society Pro Bono Services to develop the Workers' Guide to Injury Compensation, which is a publication that is freely available to the public on the LSPBS website. Mr. Shergill was also featured in an informative video on workplace injury claims in Singapore. And this has been translated to multiple languages and is available on YouTube. This evening, we are also fortunate to have our returning speaker, Mr. Patrick Tay. Patrick is the Assistant Secretary General of NTUC and Director of NTUC's Legal Services and Strategy Division. Concurrently, he is an elected Member of Parliament and a member of the NTUC Central Committee. He chairs the Government Parliamentary Committee for Education and is a member of the GPC for Law and Home Affairs. He has been representing the labor movement in all the tripartite work groups to review and update employment and industrial relations legislation. So Raj and Patrick, thank you for joining us today.
Pleasure. Our pleasure.
So to give our audience a sense of what to expect, I will first outline what we'll be discussing in this webinar. So for the first part of our session, we will be talking about workplace safety and the basic entitlements as well as the law. We will then be talking about the shifting environments of the workplace and consider whether the same rights would be extended, and especially considering work from home situations in contrast to working on site. We will also consider in non-traditional work settings whether one would receive the same benefits nonetheless. For instance, if you're working as a freelancer. So to make it easier for all of us to discuss these topics and also for our audience to visualize these situations better, we will be using some hypothetical scenarios and they'll be flashed on the screen. So now let's first start with a quick discussion about the laws that would apply. So there are 2 main laws that deal with our topic today. The first is the Workplace Safety and Health Act, which is WSH. And the second is the Workplace Injury and Compensation Act, which we call WICA. So Raj, I'm going to turn to you and we're going to start the session. So firstly, can you share a bit more about what WSH and WICA, what does it cover? And can you also elaborate a bit more on what WSH requires employers to do?
Sure. So let's begin with the WSHA, the Workplace Safety and Health Act 2006. This is a framework of guidelines and regulations to ensure that reasonable measures are implemented to ensure the safety, health, and welfare of workers at workplaces. There are three guiding principles. First, to reduce risk at source by placing responsibility on stakeholders. So stakeholders would include the employers, principals, occupiers, manufacturers or suppliers, employees, and the self-employed as well. The second guiding principle is to promulgate industry standards for safety and health systems and outcomes. The third guiding principle is to put in place enforcement measures such as remedial orders and penalties for non-compliance and risky behavior. So the primary focus of the WSHA is on a safe working environment. And in this regard, the Act is very comprehensive. It regulates hazardous substances and machinery and equipment which would pose safety and health risks. And it uses detailed subsidiary legislation which covers various aspects, such as lifting operations with cranes, hazmat industries, and even COVID-19 measures. However, we should bear in mind that Section 60 of this Act actually provides that nothing in the Act is to be construed as conferring a right of action. In other words, giving you the right to sue somebody for a breach of the Act. So while the WSHA does contribute to workplace safety, the focus when it comes to an injured worker's claims is really on WICA, the Work Injury Compensation Act, and common law claims. So in relation to WICA, the Work Injury Compensation Act, we have actually put up a workers' guide to compensation in collaboration with the Law Society's Pro Bono Services Office. And that's available online free of charge. It is quite detailed and it covers the framework of the Act, common law claims, and frequently asked questions. For today, I will focus on a few questions, mainly in the context of the Work Injury Compensation Act, with a little bit of the common law. Now, if we look at WICA, what can you claim in terms of compensation? Compensation is based on a percentage of permanent incapacity. And in addition to that, you get medical expenses subject to a cap of 45,000. And you also get your medical leave wages. Again, this is subject to a cap of full losses for the first 2 months, and then after that, 2/3 for the next 10 months. Proof of fault is not required, so you don't have to show that somebody was in the wrong, but you must show that the injury was sustained due to an accident in the course of work. Generally, the compensation is much lower than a common law claim, but it is a quicker way to get your compensation. Generally, claims take about 6 months. Now, if we contrast that with a common law claim that you see on the slide, what is the common law, people ask? The common law is simply the law that has been developed by the courts and the judges over the years. Singapore has codified some of it, but it continues to be developed. Common law claims for injuries, whether arising from negligence or breach of employer's duty, would involve proving fault on the part of the party that you claim against. There is no requirement to show any permanent incapacity. There is no maximum cap for medical wages or your medical expenses. So generally, it tends to be much higher damages compared to a WICA claim. Damages there would comprise general damages for pain and suffering, loss of future earnings or loss of earning capacity, and cost of future treatment. You would also get what we call special damages in terms of your medical expenses, no cap. your loss of income, again, no cap, and your transport expenses. So a few questions that have been asked of me in relation to WICA. When should you claim under WICA? You should claim under WICA if it is hard to establish fault on the part of your employer or third party for your injury, or you yourself are at fault, or frankly, it is one of those freak accidents where no one is at fault. You would also claim under WICA if you are more interested in receiving your compensation quickly. Now, generally, however, whenever you can establish liability, get good legal advice, and bring a common law claim, because, like I said, it's probably going to be much higher damages. Now, the next question is this. What are the critical deadlines involved for a WICA claim or a common law claim? You have 1 year to commence your action for a WICA claim, and you do that by giving notice to your employer. For a common law claim, on the other hand, you have 3 years from the date of the injury, or the 3 years begin to run from the earliest time you would have had reasonable knowledge of your right to claim. It is very important to note that if you have commenced a WICA claim, but subsequently want to go under common law, you need to withdraw the WICA claim because you cannot claim for both. It's either or. And you can withdraw that WICA claim anytime before the MOM or the insurer issues the notice of assessment. After that, you must withdraw your claim within 14 days of being served with the notice of assessment if there is no dispute, or within 28 days of service of the notice of assessment if there are disputes which are later withdrawn. Now, what is the significance of this? There have been a number of people who have been caught unawares because WICA is meant to be practically an automatic procedure. The employer is given notice of the accident and they put up the claim with the insurer, and then compensation begins to be processed. But if you do not withdraw your WICA claim within the requisite timelines, then you may lose out on the chance to bring a much higher common law claim. So the next question that has been asked is this: who can claim under WICA? So any local or foreign employee can claim, so long as you are employed under a contract of service or a contract of apprenticeship, regardless of your salary, your age, or your nationality. Independent contractors, which are usually self-employed persons, domestic workers, and uniformed personnel, generally cannot claim under WICA. So a few pertinent points arising from questions asked in the past. Yes, you can still claim under WICA even if you are no longer working for the employer. Yes, you can claim under WICA even if your work pass has been cancelled. Yes, you can claim under WICA if the accident happened while you were on flexi work assignment. And yes, you can claim under WICA if the accident happened while you were on an overseas assignment. So what are the types of injuries that will be covered under WICA? I'm concentrating a little bit more on WICA in this segment because usually for a common law claim, you will see a lawyer and you will get advice on how to go about the claim as well as the amount of damages. And you should also be asking for advice on how much you will be charged in terms of legal costs. So coming back to WICA, it covers 4 types of injuries. Injuries caused by an accident arising out of and in the course of your employment, injuries sustained while on overseas assignment, injuries that are occupational diseases arising from the course of employment, for instance, noise-induced deafness, occupational asthma, or occupational skin cancers. It also covers diseases contracted from exposure to biological or chemical agents at work. WICA does not cover injuries due to the influence of alcohol or drugs. It doesn't cover deliberate self-injuries or aggravation, intentional aggravation of an accidental injury. It doesn't cover injuries due to fighting or assaults unless the victim was acting pursuant to his right of private defense. He was defending himself, or he was trying to break up the fight, or his employer had requested him to intervene to try and safeguard life or property. So what are some examples generally of injuries that are deemed to occur in the course of employment? Remember, to recap, there are three requirements for a claim under WICA: an injury, an accident, and that it happens in the course of employment. So coming back to the course of employment, if you are traveling to or from work on company transport, that is deemed to fall within the course of your employment. If you are in your workplace and you are taking steps to rescue or protect anyone or any property in an emergency, that falls under the course of employment. And likewise, generally acts done for the purposes of or in connection with your employer's business, even if you were acting in contravention of law or orders given by the employer in certain situations. So those pertain to what aspects are covered and what a WICA claim entails. Practically speaking, how do you go about making a WICA claim? So step one, report the accident to your employer. The WICA claim is automatically commenced once your employer is notified, whether by email, SMS, or WhatsApp. Next, once this happens, your employer is supposed to report the accident to MOM within 10 days. If your employer doesn't do so, it is an offense on the part of your employer, and you can inform MOM directly by making the incident report. Keep a copy of your medical documents and give your MCs and medical bills to your employer. It would also be good advice to keep a copy for yourself and some proof that you have given that notice to your employer and all these medical documents to your employer. So what will then happen is you should receive a notification letter by post once MOM is notified. So keep this letter, which will include your case reference number. So that's step one. You've reported the accident to your employer. What comes next? Step two, claims processing. So you or your employer will receive a form and a letter stating that your claim is being processed. Submit that claims process form, and you must also document your average monthly earnings, the injury site, and the details of the injury. You can submit this at Wix Submit Online or Post. So, step three, going for your medical assessment. So you must attend all medical appointments. There's no restriction as to which hospital or clinic that you need to seek treatment from. But as far as possible, practically speaking, don't keep changing hospitals and clinics because it becomes very difficult to gather all the information, and doctors do charge for medical reports. So step four, we've arrived now finally at your compensation amount. The designated WICA insurer will calculate the amount and will issue the notice of computation. So what happens when that notice is issued? If you or your employer has an objection to the notice of to that compensation amount, file your notice of objection within 14 days. If there's no objection by either party, then the insurer or the employer is required to issue the compensation check within 21 days from the notice. What happens if the employer refuses to pay? Contact MOM. So, practically speaking, we've gone through the steps involved in making that weaker claim. I'll just recap it quickly. 4 steps. Number 1, report the accident. Number 2, process the claim. Number 3, go for your medical assessment. And number 4, file the notice of objection if you're objecting to the compensation amount, or if you're not paid within 21 days, call the MOM. So, practically speaking, what evidence should you have on hand for a weaker claim? You should have evidence relating to your accident or your injury. And this could comprise WhatsApp messages, SMSs, video footage, timesheets to prove that you were there and this injury did occur, as well as medical reports. So it would be good to tell the doctor so he can also document that you were involved in a workplace accident. You should also have on hand evidence relating to your income. So this would include your contract of employment or your pay slips. So what can you claim for in terms of various scenarios? Generally, to recap, there are 3 main items of claim under WICA. First, your medical expenses. Now, these include all expenses incurred towards medical attention, such as transport, physiotherapy, medicine, prosthetics, and other equipment, as well as medical examination and consultation fees. So that was 1, medical expenses. Number 2, you get your medical leave wages. And this would include overtime, traveling allowances, traveling concessions, food allowance, housing, and CPF. Remember that it's subject to a cap. For the first 2 months, you get full pay, and for the next 10 months after that, you get 2/3 of your pay. After a year, you don't get any more compensation for medical leave wages. Now, the third item that you get under WICA is a lump sum compensation. Now, this is payable in the event that there is permanent incapacity or death. The amount payable is based on a formula that's calculated based on your average monthly earnings, multiplied by an age factor, and then multiplied again by the percentage of permanent incapacity. That percentage would be found in the schedules to WICA, which would document the percentage assigned to each type of injury. But to simplify matters, the MOM has got a very helpful online tool called the WICA calculator. And you can use that calculator to get an indication of how much compensation you would receive under your WICA claim. Now, a few FAQs, frequently asked questions that keep cropping up. Who pays for your medical expenses? Now, under WICA, the employer should pay the medical expenses directly to the approved medical institution or hospital. Even under the common law, employers are responsible to pay costs of a foreign worker's upkeep, including medical treatment. However, if you have a common law claim and the employer is refusing to make these payments, what you could then do is you could apply through your lawyers for an interim payment, which is an advance on your damages. So 2 other common questions. First, can my employer fire me on the grounds that I can't work due to my injury? And the answer is yes, your employer is entitled to do so. But from a legal perspective, if your employer does so, then you would probably have a higher claim for pre-trial loss of income and perhaps even loss of future earnings. The next question is how much you have to pay your lawyers. Now, that would probably be a very good question to ask. Now, if we're talking about WICA, strictly speaking, WICA is meant to be a quick and simple avenue to get compensation. Lawyers are generally not required to process WICA claims unless there are serious disputes raised by the employer. So if you're engaging a lawyer, check the legal fees payable first. The cost that the insurer is required to contribute to your legal fees tends to be quite low in WICA because it is primarily meant for quick compensation, like I said, not long drawn legal disputes. Now, under the common law, there are controls in place to regulate a lawyer's fees. So if it's a motor accident claim and your damages are more than $5,000, the public trustee will usually determine the amount of cost that you pay your lawyer. And it's very simply done. In addition to damages, the insurance company of the third party would have to contribute towards your legal costs. This is called party and party costs. The public trustee will look at the party and party costs and usually issue a determination on a certificate that you would pay about 10 to 20% of that party and party cost contribution, which tends to be a very small fraction of the damages. Now, for other claims, such as a common law claim against your employer for breach of employer's duty, or a common law claim against a third party, outside of the motor accident sphere, these costs do not tend to be regulated. So first, ask the lawyer very carefully how much and when the lawyer intends to bill you. And if you feel that the lawyer has charged you too much, you can always have the lawyer apply to court for the court to assess the legal cost payable. So I think that would wrap up the first segment on Workplace Safety and Health Act, as well as WICA and in some regards the common law claim. I hope that has been helpful.
Raj, I thought that was a very comprehensive sort of overview of WICA, and I think you really touched on, a lot of the pertinent areas, and especially areas that, our audience would need to know, at least the fundamentals of it, right? You mentioned also the Workers' Guide to Injury Compensation. So I think a lot of the information that you shared and that you had, very generously, gone through with us, I think a lot of it is in that guide. So if we could have the link to the Workers' Guide, that'll be great, so that everybody who was trying to catch what Raj was saying, you can go back and review the guide. So I think it'll be really helpful for us to understand how the law that we have just heard is being applied in practice. So before we move on to the more complicated scenarios, I want to consider a situation wherein WICA and WSH would traditionally apply. So Patrick, I'm actually going to ask you to consider this very typical traditional situation. And I would like you to comment on the recourse that's available here, and give us your viewpoints also on what further to what Raj has said. So I'm going to read out the scenario. So Vanessa works in a factory and operates machinery in the course of her work. Unfortunately, while she was operating the machinery, her hands were caught in the machine, and as a result of it, she lost 3 of her fingers, which is very sad, and she has difficulty performing her responsibilities under her existing job.
Yeah, thanks, Amira, and thanks, Raj, for the wonderful, more than just a preamble. We had a legal primer for workplace safety and health and WICA all in a matter of 25 minutes. Wonderful. And he has encapsulated the key principles. So drawing from what he shared earlier, if you see this particular scenario, hypothetical situation, actually not really hypothetical, these things actually do occur in the workplace. Myself being from NTUC in the labor movement, we do see this and do meet with workers who face such accidents and who meet with such accidents as well as such unfortunate accidents as well. And we, as you can see in this situation, it's a clear-cut situation, quite fixed nicely like a cookie cutter into Raj sharing earlier. Something that's in the course of employment, is an employee. We take it as in this situation as an employee in this employment relationship, it's a worker, and therefore it's injured whilst working, and based on a very straight reading of the facts. and therefore would be entitled to a WICA claim, or as Raj shared earlier, if he or she so decides, then a common law claim. I thought useful to augment what Raj shared earlier, and in particular in application to this particular scenario. I think there are three key things I thought to share with the audience out there who are viewing this as well as watching this. I think firstly, it's very, very important is that you're not alone. So if you know of anyone who faces an injury, or you yourself have faced injury, or you have seen colleagues who have suffered some form of incapacity or injury of such nature, there is help and there's support available. Raj earlier shared about reporting the incident. I can't emphasize more the importance of that, because there's some timelines, and so therefore do report it as contemporaneously as possible. That's one important tip. Secondly, as Raj mentioned earlier about notifying MOM if you do face any issues. So if you are in a unionized company or if you're a union member, I thought to emphasize that you actually have union leaders as well as industrial relations officers on the ground. And my colleagues, well, I have a team of colleagues back in the NTUC. So you can call our hotline or seek help from union leaders on the ground in your workplaces and in your factories. In case you face any problems or impediments, or you are unsure or worried, they are people who can support you in that journey, and also give you some information and guide you along that journey of filing a WICA claim. That's a WICA claim, or even a common law claim. Yes, you need legal redress. Consult your lawyers. So that's one important area. Second important area I wanted to augment is it's a scenario of workplace safety as well as work injury. Also to update everyone that our workplace safety and health law or act, as well as the related laws and subsidiary legislation, as well as the WICA, Work Injury Compensation Act, has gone through quite a number of amendments in the last 2 decades, particularly in the last decade. And as you can see and have read in newspaper or even on social media what's happened in the last 6 months, is quite worrying. And also why this big imperative by our LawWorks partnership to organize this evening's legal primer, because we have seen quite a number of fatalities that's happened at workplaces in the first half of this year. I think more than usual. I think now that we are getting out of the pandemic, there's deadlines to rush, accidents do occur. And some, if you look at the facts of the case and whatever information you get off the media, sometimes can be really freak accidents, very unfortunate ones as well. And it's not just confined to fatalities, because yes, you do hear of fatalities being reported, but also minor trips and falls. Now that we are working from home, we'll talk more about that later on. But I thought important to realize and acknowledge the fact that these two pieces of legislation actually do get reviewed quite frequently, to keep pace in terms of the amount of compensation when someone faces death or permanent disability, as well as the percentages, and as well as the various formula and tables and the scale of compensation, which Raj shared earlier, that are available in the regulations. I think it's there in the schedule and it's constantly reviewed. Likewise, for the Workplace Safety Act, we did not go into it, but actually there are quite significant obligations on employers. I know there are employers out there who are tuning in and watching this. There are significant obligations on employers, as well as safety officers and line supervisors and managers on the ground. So do take note. There are various programs that you can attend, and many of these programs and of course primers and education training for the ground as well as for employers are available and heavily subsidized. And the third point I wanted to just finally interject is that as you can see in most of our scenarios that we shared, it involves employees in in private organizations and as well as in a private setting. However, as you all know, Singapore don't just have private sector employees, we have public sector employees as well. So public sector employees are not actually covered by WICA. There's actually a deck, a nice couple of volumes of what we call the Government Instruction Manual that covers public sector employees. So if you are a public sector employee and if you do get an injury in the course of employment, not to worry, not that you don't have a claim, but go do the same, you go through the same process, notification through the HR or manpower officer or the HR department. And the whole process, similar, well, it mirrors the WICA of sorts, but through the Government Instruction Manual. which many of you who as public sector officers will have access to.
Thanks, Patrick. So there's a second part to this scenario, right, where we consider how the laws are being applied. So I think you've touched on it, that it will cover death, of course, but maybe I want to hear from you from the employer's perspective, and perhaps, in this situation where Joseph, right, who is Vanessa's husband, slipped and fell to his death, right? So no one pushed him, and we presume the construction site would have the necessary notices, and whatever safety measures that the employer could have, put in place were already done. So what kind of liability or responsibility would, the employer be getting themselves into in this situation?
Sure. Before I let Raj augment or add on to it, but I think basically, whether it's slip and fall or whether it's a situation where it's a very tragically fall from heights. These are accidents which we hope never happen. I mean, but unfortunately, sometimes accidents do happen, and therefore, some of you may have relatives, friends, or even colleagues who have faced such unfortunate incidents. Therefore, stay calm. I think very important to be aware that there are actually recourse and support available. So, for example, most companies would have their HR departments and sort of support to help next of kin as well as family members to go through this process. Again, also taking consideration whether it's a local worker or foreign worker. In fact, in the labor movement also has the Migrant Worker Center, which actually helps and supports migrant workers if they face accidents, or in such cases, if you have colleagues or friends who are migrant workers and who face such accidents, their next of kin can also seek out our Migrant Worker Center. So you work very closely with Ministry of Manpower as well as our tripartite partners, including with the embassies as well, particularly for migrant workers. But traditionally, and in this, as I mentioned earlier, if you are working in a unionized environment, go to the union leaders, call the NTUC hotline. We will be able to support you and walk you the journey. We have done so in the last couple of months, where you've heard about a couple of incidents involving both employees as well as freelance workers. We have actually different units within the labor movement supporting the next of kin in that journey, and seeing where we can render help and support so that they can tide through this difficult period. Yeah. Raj?
Sure. In both these scenarios, I should think a lawyer is going to realize very quickly that there are very clear-cut cases. And for instance, Vanessa's case under WICA, it's quite straightforward. Regardless whether or not the employer is at fault for failing to develop a safe system or fence the moving parts, WICA is non-fault based. The three requirements are clearly satisfied. You have an injury, you have an accident, and third, it would have happened in the course of employment. So Vanessa is definitely going to get her medical leave wages, her medical expenses subject to the cap. And by way of a rough idea, I ran a simulation on the MOM calculator, and she's probably going to get about 80,000 if she's 30 years old and earning about 1.5K per month for permanent incapacity arising from the loss of 3 fingers. It's relatively low, but bear in mind that WICA is no fault based. Now, under the common law, she would probably have to prove liability in terms of breach of employer's duty or negligence on the part of the employer. There are some exceptional cases where the judges have held that the employer could not have done anything to make it safer, and the worker was largely at fault. But that said, there is a very heavy duty on employers under the common law to provide a safe working place, a safe system of work with adequate supervision to make sure that it is followed, and adequate tools and manpower. So there is probably going to be a case here in terms of an unsafe system. Sometimes, under the common law, there is something called contributory negligence, where I may be partially at fault, but it doesn't stop me from recovering my claim, subject to some small deduction, perhaps on account of my contributory negligence. So I don't see an issue proving liability. The damages under common law will probably be much higher, roughly about 30 to 50,000 because of the loss of 3 fingers, which has a multiplying effect on her overall disability. She will be entitled to loss of earning capacity to compensate her for the risk of losing her job. And if a lawyer is acting for her, if she has not already lost her job, he would probably claim provisional damages upfront, and she can even go back to court if she subsequently loses her job. If, which is likely, she has already lost her job and is already suffering a loss of income, she's going to get, assuming she's 30 years old, something like 24.92 years worth of lost income. So this is not going to be a problem under common law. Her cost of future treatment, her pain and suffering, her loss of future income, as well as her expenses would be taken care of. Now, I would go so far as to say that when a lawyer sees that these cases are going to be quite clear-cut, there are many competent lawyers out there from my area of practice who would actually defer payment of the costs and the disbursements until the end of the claim when the employee recovers her damages. A bit of advice, best commence the common law claim in such situations within 1 year instead of the usual 3 years. Why? Because if you commence a common law claim within 1 year, which is the time frame for WICA, even if for some unlikely reason the claim is dismissed, the court can still award you your WICA compensation. So coming quickly to Vanessa's husband, Joseph. In the first place, falling from height in a situation like this should not happen because the legislation, such as the WSHA, contains specific rules on working from height. For example, the Workplace Safety and Health Work at Heights Regulation 2013. It sets out requirements for fall prevention plans, training, supervision, guardrails and barriers, travel restraint and fall arrest systems, approval and inspection of these systems by competent personnel, such as professional engineers. So there are safety briefings and supervisions required, as well as safety assessments with approval permits. So if you look at the legislation that the government has put in place, these accidents should not be happening. Nonetheless, as Patrick alluded to, the reality that these incidents do tend to happen sometimes due to human error or perhaps even neglect. So if it has happened, then under WICA, the 3 requirements are easily fulfilled. An accident causing death in the course of work. You can run a quick calculation on the MOM calculation tool, right? Assuming he's age 30 and similarly earned about 1.5K, he died shortly without incurring medical expenses, his dependents are still going to secure about $183,000. So there is help for them. Now, under the common law, if he brings a common law claim, given that he fell despite all the precautions that are mandated, there would likely be a breach of employer's duty or negligence on the part of one or more parties involved at the construction site. So a lawyer would be able to examine these issues and put up reasonable advice. So there are good prospects of establishing liability subject to the facts. The damages are, of course, going to be much, much higher under common law. So for anyone or their loved ones who are in either of these situations, what I would say is do not hesitate. Reach out to the MOM or your employer, and if you need more help in relation to whether you should claim under WICA or do you have a viable claim under common law, which could be higher, there are many agencies that can help to put you in touch with a lawyer, and you should not have to worry about legal fees and disbursements, right? So I hope that's reassuring, Patrick and Amira.
Thank you. Thank you, both of you. I'm going to try to speed up a little bit more because I feel that the responses you are giving to our audience, are very, very helpful. I like how you have sort of broken down each situation and try to see how the elements will be made out so that our audience can understand whether there is a successful claim or there would likely be a successful claim in the situation we've just seen. So I'm going to combine the next scenario that we have, and this is going to be of interest to our audience, especially since we've received a related question I believe you have been waiting for this scenario, which is working from home. So working from home is undeniably a part of the employment landscape. So if not yourself, a friend or relative of yours would likely still be working from home on some days or even for good. So the scenario I have on the screen here is Rachel has been working from home since the start of circuit breaker. And she has recently slipped and tripped over some wires and working fouls. So she slipped and tripped over some wires and working fouls while working at home, and she has suffered some bruises and fractures. And the second part to this is that she has also realized she has been working longer hours while at home. So her prescribed working hours are potentially 9 to 6, but she has been working beyond 6. Many of her colleagues and all supervisors have been conducting meetings and or calls past office hours, even on weekends, and also expect her to respond very promptly to the emails, right, outside of work office hours. So as a result of this, there has been a bit of a blurring of boundaries here, and she's been feeling very stressed, and she can say she's somewhat depressed. So Raj, I'm going to first ask you, a very simple question. And this is also a question that we have received from Pigeonhole. So if accidents happen while one works from home, which is in this situation, what are the boundaries to decide whether the WICA claim is valid, and to what extent is the claim even valid if it is at all? So
Sure. So as a very quick caveat, the employer does not have control over her home and cannot be blamed if it was unsafe and there were tripping hazards. So obviously there's no breach of duty or fault on the part of the employer which caused the fall. So there would be no valid common law claim. But under WICA, which is not fault-based, if Rachel can prove that there was an accident in the course of work that caused her to slip and sustain injury, she would probably be able to claim. Now, if you ask me, there is an accident given that she fell, and it has caused an injury, there is no way that Rachel is going to say that it was unrelated to work. Rachel, if you're watching this, I think she's probably going to say that she was working when it occurred, and getting up to use the toilet or get a drink will not bring it outside the scope of work, as these are incidental activities that normally occur in the course of work. Now, it would not matter that Rachel had been working from home at the time of the accident, because Section 2 of WICA defines the workplace as any premises where a person is at work, is to work, or for the time being works, or customarily works. In fact, in a parliamentary debate on the 4th of June 2020, the learned Minister of State for Manpower addressed questions pertaining to compensation for workplace injuries given the prevailing work from home arrangement. It was at the height of the COVID-19 pandemic, and the minister stated that work from home arrangements do not change an employer's responsibility for work injury compensation. The key would be to ascertain that the injuries arose while doing work at home and not while performing non-work activities at home. So that's a fact-finding exercise, no different from all other WICA claims. So in this case, I think I would agree with the minister. Rachel would likely be entitled to compensation.
Actually, Raj, I'm the culprit. I was the one that filed the parliamentary question, which resulted in Minister of State replying.
Brilliant.
So actually, what has happened in the last 2 years since the start of the COVID-19 pandemic, with the circuit breaker for 2 months and periodic, high key and low key kind of arrangements. I think increasingly there are more and more flexible work arrangements, hybrid work arrangements, work from home arrangements, work from anywhere arrangements, and now I think it seems to be like the next normal in many organizations. So this topic of working from home is going to be very, very important. So I can't emphasize more that even NTUC and Labour Movement, we've been watching this space because we do hear of workers who are injured while at the cost of working from home. So that's why we filed that question, and we, in fact, I filed the question last year and then again last month, which were both answered. So in summary, in response, from April 2020, when the first circuit breaker happened, right till last month in June 2022, there were a total of 65 work in WICA claims in a work from home situation. So out of which Minister of State replied that 41 of the claims were admitted. 41 of the claims out of the 6 claims that were made under WICA for work from home injuries were admitted, meaning that there was an injury it was in the course of work, and it was sustained while in the course of employment and in a home scenario. So that's the latest update fresh from the oven for all of you. Then you'll be asking, what about the remaining claims other than the 41? There were 5 of the claims were actually now being assessed and investigated on, while the rest were assessed as not being in the course of employment. So very, very important. I think Raj alluded to a very, very important fact that, trips and falls, Minister of State actually did make a very, very important statement there. Because if you look at it, a good reference point will be what happens in the office and what happens in the home office environment. For example, if you are in the office environment, if you are walking to the toilet and you slip and fall and suffered a fracture, will that be covered? Yes, that'll be covered. So similarly, if you're at home and you're not going gardening in your backyard or doing something funny in the balcony
Or rollerblading
at home, rollerblading at home, but really walking to the toilet, tripping over some wires or even some files dropping on you, or carpal tunnel, or even falling off from your swivel chair. These will be incidents which will be in the course of employment and therefore would attract a WICA claim. So just to reassure everyone that doesn't mean that when you work from home, you are totally void of any WICA claims. There were actually 41 out of 65 claims that were filed that were successful and classified as a successful WICA claim.
That's very good to hear. So I feel that, I think that really helped, right? Because we know that, these are easy to identify injuries, right? Bruises and fractures. And we can clearly say it's in the course of employment, and the environment doesn't matter, right? But what about the second part to this situation, where we're talking about additional working hours? So this is past office hours, right? This seems to be an expectation to work, beyond the official working hours. And this is about mental health, right? So she's feeling depressed and stressed, right? So it's very hard to sort of identify and see, precisely what is the injury here. How do we treat this situation? Raj, could I ask you, would employees like Rachel, whose mental health has been deteriorating due to work, right? Would they be able to also, be successful in the WICA claim?
Okay, so I'm going to take you into a bit of a deep dive into the law in this area, because psychological injuries, psychiatric injuries, are subject necessarily to a number of safeguards, because unlike a physical injury where there is an obvious impact on people within that radius, psychological injuries can impact a very wide range of people, and often enough, there's no physical way of confirming whether or not this injury is suffered. So let's look at it in terms of the same framework. Under WICA, you need to show an injury, and secondly, that it arises from an accident. Thirdly, arising out of the course of employment. So first, proving an injury. Now, stress and somewhat depressed, which is what I read there, may not qualify as an injury. The law states that psychiatric injury must manifest in a medically recognized condition. As a general rule, sadness, grief, or general distress are not covered because they are held to be expected parts of everyday life. For a claim to succeed for psychiatric injury, there must be a recognized psychological injury that is diagnosed by medical experts under what we call the DSM-5 criterion. That's the Diagnostic and Statistical Manual of Mental Disorders. So for instance, in Manmohan Singh, a Court of Appeal case in Singapore, it was decided that a claim for post-traumatic shock and depression could not succeed because the psychiatrist's medical report did not mention that the claimant had suffered a recognizable psychiatric illness, while the medical report noted that he was depressed and grieving over the loss of loved ones. Ordinary sorrow and grief were not actionable. So if we can cross that hurdle, so if we can establish a recognized psychological injury, then it would likely pass the first requirement. You have an injury. And I think if it can pass that requirement, then psychological injuries are claimable under WICA. Why? Because WICA generally refers to injuries and does not expressly exclude psychological injury. In fact, in the second reading of the WICA bill in 2019, the Minister of State for Manpower, Mr. Zaki Mohamad, stated that employees can be compensated for mental disorders and any resulting incapacity, even if there's no physical injury, if the following criteria are met. A, clinically diagnosed mental disorder, which resonates with what I related about what the Court of Appeal observed. Second, it's caused by an accident. And third, in the course of employment. So secondly, under WICA, you would now need to prove an occurrence coming within the definition of an accident that triggered the condition. Now, an accident at common law is generally defined as an external, sudden, fortuitous event. This has been somewhat relaxed in certain cases because WICA is a piece of social legislation. So, for instance, if I have engaged in a specific strenuous activity that causes me a stroke or heart attack due to my pre-existing condition, it has still been held to be an accident that triggered the condition. The problem here, however, is that we still, under WICA, need an occurrence as opposed to a general decline, perhaps, into depression. And the need for this was very recently clarified in the Singapore High Court. There was a case called Sompo Insurance against Tay Jia Yi in 2022. And the judge there said, an injury by accident within the meaning of the act requires the claimant to point to an occurrence in the course of employment that more likely than not caused the injury. And the claimants there failed to show this. So if this is a final occurrence that broke the camel's back, for instance, she's already stressed and she's been reporting it to her employer. And she's been telling her employer, hey, this is not what I signed up for. And meetings are going way beyond office hours, sometimes into the wee hours of the morning. And I'm beginning to feel stressed, depressed, I can't cope. And the employer ignores this. And then we have one final long meeting after hours that where perhaps she's been taken to task and it breaks the camel's back. Then we can argue that this is an occurrence that satisfies the definition of the accident. But if it's just a gradual condition and the employer has not been told, then I suppose there might be a problem. Now, the third factor is probably satisfied because this condition would quite obviously have arisen in the course of employment. So the main impediment at WICA is this. If there is unlikely to be an accident in terms of a specific occurrence at work, even if she's working from home or otherwise, then it could prove to make the claim very difficult to succeed. If Rachel is watching this, however, and can prove to her medical advisors that there was a specific occurrence where she overextended herself mentally for one instance, for instance, one particularly long meeting resulting in a sudden breakdown, then there may be a case to argue. Now, moving on to the common law very quickly. At common law, again, you have to prove that the employer is liable for the breach of this duty and that it similarly causes a recognized psychiatric injury. So why are the courts so concerned? To give you a simple example, can a driver colliding, let's say Patrick collides into me on the road. Can you imagine, Patrick, if you are now exposed to 20 claims for post-traumatic stress disorder and loss of income by witnesses of the incident at the accident scene, or people who saw it on the news, as well as all my relatives who come to see me in hospital? I mean, clearly you're going to go under and it will be quite unfair for the insurer. So that's why we've got to contain the ambit of liability so that you don't have indeterminate debt, right? So that's why the courts have been very careful to draw a balance between the rights of a claimant and the potential defendant. So in Nyam Kong Singh's case, the Singapore Court of Appeal came up with a framework for common law claims. There are 3 requirements to establish that there is a duty of care, which says that I should take care to that I do not cause you such psychiatric injury. The first threshold requirement, it must be foreseeable. That means I can expect it in the normal course of things. It must be foreseeable to the employer that their conduct might result in some form of psychiatric harm. So I can already see two problems here. First, like I said, stress and somewhat depressed may not be claimable. There must be a recognized psychological injury diagnosed under the DSM-5 guidelines. Now, secondly, the injury must be foreseeable to the employer in workplace stress cases. The courts have accepted that an employer is entitled to assume that an employee can ordinarily handle job stress unless the employer is made aware of some unusual vulnerability. So where the employer has got no reason to suspect that Rachel is laboring now under a lot of stress and may succumb to a traumatic event that causes her psychological injury, then the employer may not be held liable because it's not foreseeable, especially if Rachel is at executive or managerial level. So these are highly paid jobs and it's going to be relatively stressful and time consuming. There may also be an issue if you are dealing with an oversensitive person. So again, it may not be reasonably foreseeable, right? So if we can cross that hurdle at common law and you can understand why it's there, right, that it must be foreseeable, then we need to establish that it's sufficiently close in terms of the parties' relationship and the traumatic event and the psychiatric damage. And the last consideration is whether there's any public policy that would bar such claims. I do not see such an issue here. So in summary, in an employment context, where the employee is informed the employer that she's now working 24/7 compared to before, she cannot cope with these new expectations and is feeling stressed and anxious. And the employer continues overworking her despite being made aware that there is a very exceptional strain occurring now mentally and psychologically. Then there's arguably a valid claim. If the employee finally snaps, preferably at some traumatic super long meeting, like I said, and she can establish through a qualified psychiatrist that she suffered a recognized psychiatric illness. I hope that makes it clearer.
I think it's wonderful, Raj. You really gave us a very comprehensive articulation, a legal response to that this particular scenario. But I just thought I'd give some thoughts and comments on this particular area because being from NTUC in the labor, when we have been seeing quite a number of workers, particularly with work from home arrangements, and well exacerbated by the fact that many of us are putting in much more longer hours. Well, there's different school of thought. Some say we are less productive, but actually, many of the professionals, managers, executives that I know and I speak to, anecdotally have ended up putting in much more hours in front of the laptops, smart devices, particularly during this past 2.5 years, whilst working from home or whilst in hybrid arrangements. And therefore, hearing what Raj in very, very great detail has shared, I think it's just a call out to employers and HR practitioners and human capital practitioners out there, even some of you who may be directly or indirectly been involved in this employee or relation space, to take note, because we are actually seeing a rise or a surge in number of mental health issues. Yeah, as you know, depression, as what shared, it varies from the big spectrum. There's a big spectrum. Whether it borders into schizophrenia or mental disorder, and while there's mild depression, I think there's a big spectrum. So I think we have to be watchful. And in this space is something which I think the tripartite partners, including the government, is paying some big attention on because of the various next normal that we are facing with more hybrid and work from home arrangements. And we do see a rise in cases of people feeling burnout, stresses. Maybe that's one of the reasons that has caused the great vaccination and great reshuffle in the last 12-15 months. But I think more importantly, it's for HR practitioners and employers out there to have progress, not just fair and responsible, but also to have progressive practices when you have your employees working from home. I mean, simple things like, do give them a right to disconnect when it's after office hours where possible. I know some of you who are PMEs actually operate because in a Asia Pacific or global kind of role where you need to do conference calls. I remember during the last 2 years when I had to connect with colleagues in the US or even in Europe. My work starts at 9 p.m. and I'm connecting those in America, and after 4 p.m. with those in Europe. So I think that has caused different kind of strains and demands on many of our workers, particularly the professionals, managers, and executives who are in front of the laptops most of the time. So I do appeal to all HR and practitioners and employers out there who are tuning in. Raj has shared it. Let's hope that we don't reach that tipping point and if not get there as well, and therefore build progressive practices, not just ergonomics, but really, lead by example by having your organizations come out with sound HR practices to limit excessive work hours, so that your employees have, well, in a way, work-life balance, at the same time also stay engaged and stay connected with the organization. I think that's very, very important. And therefore, that's a call out to everyone.
That's a very good call to action message, Patrick. I believe this area about mental health, right? We have a lot more to say, but I will push that to our Q&A session. I'm sure that we will have a lot more questions on that. And in fact, there was a question just now. Can I claim under WICA if I get an injury while under depression and while working? I believe, Raj, you've covered it already in your response. So we are going to move on to the next situation because we've talked about hybrid models and work from home, but we want to talk about those in the gig economy, which I know, Patrick, you're very passionate about. So for all of us, it's very common today to order meals, buy groceries, or buy something, using the delivery platform. And today there's so many riders that make up this ecosystem and basically getting the items that we want to us. So they make up this gig economy, which is growing very steadily in Singapore. So the situation that you're seeing on the screen is basically a very typical one of a freelance rider who's working with a delivery platform to assist with food delivery. Sometimes he has to deliver food in very unfavorable weather and or heavy traffic conditions, whether voluntary or not. So I want to give Patrick the opportunity to add subsequently, but Raj, I will come to you first, and then you can dissect this situation and share with us your views from a legal perspective, whether or not, if Darren meets with an accident, who's going to be able to cover the expenses of the injury that he would have suffered, and if other people are also injured in the process, right? For example, a pedestrian, a passerby, or a car got damaged.
Yeah.
Will he be responsible for it?
Right. So when I approach this question, I begin to understand very quickly that there's no clear-cut precedent in Singapore, and everything is very dependent on the facts of the case. So let's discuss the situation before we venture some answers. At the outset, there are at least three competing interests. First, the worker. The interest of the worker who, if he is deemed to be a self-employed independent contractor, he will not be protected from A, exploitation by profit-driven platforms that do not care about his working conditions, remuneration, or job security. B, lack of compensation if he gets hurt in the course of work. And C, liability that he may incur to a third party if he accidentally injures that party and he's not insured. So that brings us to the next point of the discussion in the context of these workers. We hear a lot of terms like employee as opposed to independent contractor. Now, what distinguishes an employee from an independent contractor? An employee generally works as part of the employer's organization, and he receives control and supervision from the employer as to what he does and how he does it. He cannot decline a task that's reasonably assigned to him by the employer. He's normally paid a salary and receives protection under the Employment Act. On the other hand, an independent contractor is regarded as a self-employed person in business for himself. Generally, he is not going to get a salary or job security because he's not part of the employer's organization. He frequently sets his own rates, usually per assignment, and he works independently to accomplish the task. So the employer is not even vicariously liable for these independent contractors, okay? So What about the courts? Where do the courts fall on this? The courts do not worry about what labels are attached to people in the contracts, whether they are called employees or self-employed or independent contractors. The courts look at the substance of the relationship, and they have developed tests based on multiple factors involving the extent of control, the extent of integration into the organization, and the economic reality of the arrangement. So these tests include the independent business test, where the courts look at whether the person is really doing business for himself, based on whether he provides his own equipment, hires his own helpers, takes some financial risk, and decides his own profit. So that's the independent business test. And the second test that the court seem to have developed is the control test, where the court looks at the extent of control exercised by the party over the worker. For example, with an employee, the employer will have the right to tell him how to do his job and supervise him, give him on-the-job training, assign him tasks that he really can't turn down, make him wear a logo even. Now compare that to a specialist waterproofing contractor in a construction contract, or a plumber who comes to your house, chooses his jobs when he's free or wants to work, uses his own equipment, knows more about plumbing than you or me, and sets his own price. Now, the latter two examples are obviously independent contractors. So in applying these tests, there are multiple factors that operate like a tug of war, and sometimes it is not always clear-cut whether the worker is an employee or an independent contractor. Most workers will not have the resources to take the other party to court to decide the outcome. So they do tend to be unprotected. Now, obviously, workers in the gig economy, platform workers, need some protection. And if you ask me, the best way to do it is to regulate certain industries to bring them within the employment concept or the protection of the Employment Act. To do this, the authorities will probably need to put in place controls such that these people are deemed to be employees. And I think that will come down to people like Patrick. Now, I also think that there is also a gap in the protection even for employees under the present law. Why? Because when an employee incurs a liability to a third party in the course of his work, and the employer is vicariously liable, an employer is vicariously liable for their employee's negligence if it happens in the course of the employee doing their work, right? You can sue the employee as well as the employer. But you see, when the employer is vicariously liable for the employee's negligence, the employer can also sue their own employee for a contribution or an indemnity against what the employer has to pay out. So to plug this gap, I think there needs to be legislation making it compulsory for the employer to insure the workers against third-party liability as well, or preventing the employer from suing the workers. So I think that's important to put in place. Now, that's the first group of people involved and their interests. The second group of interests that require protection, and these are people that come to me quite frequently in the course of my practice, are third-party victims who may be injured, unfortunately, through the negligence of these platform workers in the gig economy. No matter how careful they try to be, we are all prone to human error and we can make mistakes. So if these workers are independent contractors and they are uninsured, you may have a situation where a delivery cyclist paralyzes a young woman who will only obtain a paper judgment against him. So it is important to protect this second group of people, the victims of negligence, perhaps, of the platform workers. The third interest that needs to be protected, frankly, is the employer or business operator. Now, no doubt they are making a profit and should be responsible to the workers and third-party victims of their business enterprise. But we also need to realize that they do contribute to the economy and they do create jobs. So if you make it too onerous for them to operate, they cease business and this may cause unemployment, or they may pass on the cost to the consumer. I also have a cheeky colleague interning with me who actually remarked that the fourth interested party may be the PAP, because these companies pay taxes out of the profits they make. Anyway, my take is that reality dictates a government must pay heed to economic reality because you do need finance to run a country. So you do strike a balance. But that said, the government is clearly looking into the gig economy and is concerned about the workers. I've read that an advisory committee was set up in 2021, and there is ongoing discussion in Parliament as recently as this month. And that is why I think the government is taking some time to calibrate a proper and viable balance between these respective interests. And I think they will also be paying attention to developments in other jurisdictions. So that brings us to developments in the UK. There was a 2019 British case, Uber and others versus Aslam and others. And there, the English Supreme Court had to look at the relationship between large platform service providers like Uber and the individual drivers. So the Supreme Court actually held that such drivers were workers for the purpose of the UK Employment Rights Act. And so they were entitled to statutory protection, just like any other employees with employees' rights. Now, when they did so, the UK court emphasized 5 factors that pointed to an employment relationship on these platform workers' part, not independent contractors. So what were they? First, remuneration. In other words, the payment, where the remuneration paid to the drivers was fixed, and where Uber fixed the fare, not the driver. That fixed amount of payment points in favor of an employer-employee relationship. Secondly, contractual terms. The terms on which the drivers perform their services were very largely controlled by Uber. So that again pointed to an employment relationship. Thirdly, control of whether or not the drivers could accept or reject passengers, who we call riders in the industry. Now, because Uber exercised control over the types of rides that the drivers could accept and imposed penalties where the drivers refused to accept a certain number of trips, or where the rate of acceptance of trips fell below a certain level set by Uber. That again pointed to employment. Fourthly, control over the way the drivers delivered their services. And lastly, fifthly, the extent to which the drivers were allowed to communicate with passengers. So in this case, communication with passengers was restricted to a minimum, and drivers were not allowed to establish personal relationships with passengers in accordance with Uber policies, with a view to promoting uniformity in service amongst all Uber drivers. So for these 5 reasons, remuneration, contractual terms, control over acceptance of rights and delivery of services, and communication, the court held that the drivers were entitled to be viewed as employees and therefore entitled to the rights and protections that employees were entitled to. So I've looked up some developments in Singapore, and I have realized that there's been increased awareness of the issues faced by platform workers and measures taken with a view to increasing their rights. So what I see is that early 2019, an MOM presentation was put up by Mr. Am Boon Heng, the Director of Manpower Research and Statistics Department. It noted that ride share and delivery was the most common platform work, and the workers tended to be older, less educated, and they lacked control over prices and workday hours because they relied on the platform service providers for their income. You have 2021 at the National Day Rally, where PM Lee flagged the need for increased safeguards for delivery workers to receive basic job protections like other employees. Now, following this, I understand that an advisory committee on platform workers was formed to look into strengthening protection for such workers in delivery services and private hire services. Now, since the convening of this committee, I'm very sure that the issues faced by platform workers have received increased visibility. I also received a press release from MOM seeking public consultation on strengthening protection for platform workers, which I took the trouble to fill up.
So
Please
Raj,
take
I'm
that,
gonna
Patrick.
ask, I'm
Yes.
gonna ask Patrick to just
Yeah,
jump in right now
that's
and
right.
share more
Uh,
thoughts on this gig
Yeah, I
economy.
think Raj has articulated very well, the various developments as well as areas, particularly such scenarios. In fact, personally, I've met residents who have actually faced similar scenarios. One of whom I vividly on my mind. He or she was actually a food delivery rider and using an e-bike somewhere in Jurong, trying to negotiate a turn, and unfortunately the bike was kind of like scratched a huge BMW on the side, and it's pretty unfortunate because that's why she came to see me, because she got a bill from the insurance company of that BMW asking for payment for damages amounting to about $5,000 for a scratch across the front bonnet. So I think unfortunately these are real scenarios that are happening on the ground. The other scenarios would include he or she negotiating traffic, rushing to make food deliveries because we have deadlines. We need to get your food to all of you, and then falling off their e-bikes or mobility devices, but that's another situation. Another situation will also be where he or she knocks or injures someone in the course of negotiating, or sometimes maybe late in the night when we order our suppers and they have to do it in very low lighting conditions. So actually, many of our food delivery riders are actually facing various challenges, even in the course of work and trying to make a living. So what we have done in the NTUC and Labour movement, we have formed an association called the National Delivery Champions Association. So we started this a couple of years back because we saw this as a growing area, as what Raj rightly pointed out. We have today, as we are talking, we have around about 200,000 workers who are in freelance and self-employed situations, and this food delivery actually contributes to one of the big areas, minus the private hire vehicle drivers. So actually, these are increasingly more freelance workers who are more vulnerable. Of course, if you are driving a motor vehicle, there's compulsory insurance. However, if you are doing food delivery, there's no compulsory insurance on your part, or the need to buy third-party insurance, etc. So I think we have started working with the platform companies, and they've started introducing various forms of insurance to at least safeguard some of their basic rights and interests. So that's one development. So all of you out there, I know some of you are food delivery riders, some of you are private hire drivers. Please stay connected. We have these two associations, the National Delivery Champions Association, as well as the National Private Hire Vehicle Association, which Labour Movement has formed to look after your interests and rights. And we have organized various sessions, including this evening session is also dedicated to some of you out there to let you know your basic legal rights. I think that's very, very important, number one. Number two is that, yes, Raj has rightly pointed, there's a very advisory committee form, and both the associations have plugged into this advisory committee, and we are getting the ground sensing and feedback on what are the areas where these more vulnerable freelance workers are subjected to. So we are looking at these various areas, and definitely work injury compensation, things like retirement adequacy schemes, like skills training and upgrading, which is traditionally provided by employers. These are areas which we feel very strongly and are constantly lobbying. So we do hope to hear more developments from the advisory committee as well as from the Ministry of Manpower in the months to come, and more articulation on that. And finally, I thought important to also set the context, as what Raj shared earlier, this dichotomy between the contract of service and contract for service, often in legal terms called independent contractors. But some of you may have heard terms like gig workers, informal workers, contingent workers, self-employed workers, freelancers, and all these various terms, but actually they mean the same thing. They are actually independent contractors, i.e. in a contract for service arrangement. So very, very important. Raj gave you the 101 on this. Basically, know what kind of relationship and what you're signing on the dotted line. Now you don't really sign, you actually read through the terms, and then you just press on the tick or the lozenges, and then there you go. I hope you don't swear your life away, but their terms and conditions are out there in the platform. So do read fine print. That's one advice. And of course, we have the Pocket series on including for freelancers, some of the key things to look out for. These are Pocket series available both on the Law Society Pro Bono Services website, as well as the NTUC website. So you can access those free of charge. Nice materials, simple to read Pocket series, which you can access to, which covers areas including work injury as well as freelancer rights. So do check them out.
Thank you very much for your comments on the gig economy. So we're going to do a lightning speed Q&A. So I'm going to ask you a question, and I will direct the question to either of you, and you just have to answer yes or no, maybe. So the first question is to Patrick. Working in smoking environment when occupational disease happen like cancer or others, or other diseases related to smoke. So for example, you're working in an environment where people smoke and you're exposed to that a lot. Will WICA step in?
Yes, because Raj, you can chime in later, but I think there's a common law responsibility of employers to provide a safe and healthy workplace for a person or employee to operate in. So I think that's the fundamental 101.
So the answer is yes.
Yes. Yeah.
Okay. Raj, do you have a different view?
I concur. It's very clear. Yes.
Thank you. Raj, if I'm doing an internship, which I'm not, and I suffer an injury, can I claim under WICA or the common law?
So to begin with, my intern Sheena from SMU is here with me, and she's looking very intently at me.
So yes.
What was your question again?
Under common law as well?
Well,
Maybe.
I think
Okay. Next question. Patrick, if a staff is not required to report for work but turn out voluntarily to help out, very eager. The staff is not on duty, so there is a duty roster list. In the course of helping out, this staff unfortunately sustained injury. Would this be covered by WICA?
I think you will look at the circumstances of the case. If for example, it's to help out the company because of sudden production or urgent exigencies, it may well fall within the course of employment, because you actually, anyway, you're in your employer's premises, anyway, you're doing something for the betterment of the company.
Okay. So I actually had a question earlier. You mentioned about being an NTUC member, right? So if my company is not a unionized company, can I still be a NTUC member?
Yes, you can. We have two categories of union membership. So those in unionized companies, we call them honorary branch members, and those who are not in unionized companies, so we call them general branch members. You can, and you can have access to, for example, some of the express services via our Tripartite Alliance for Dispute Management at NTUC, as well as the slew of benefits and privileges which we extend to members who are even in non-unionized companies.
Raj, if a common law action against the employer fails, can the injured employee revert to filing a WICA claim so long as they're within the 1 year time frame? Because you obviously recommended, if it's in the circumstances of the case, right, to secure by filing a WICA claim first before considering, because you could drop that claim.
Yes, I get the question, and the answer is quite simply yes. And how do you rationalize that? Very simple. First, bear in mind that your WICA time bar is actually 1 year. So if you commence your common law claim within that 1 year, if it fails because you commence your common law claim during the WICA time bar, the court can then say, fine, I'll assess WICA compensation for you.
So the last thing that we have here is there were 3 tests to determine an employment relationship. Our audience caught 2 of them, which is business and control test. What's the third?
Sorry, the test
to determine an employment relationship.
Right. So these are the main 2 tests, right? That I referred to. And when applying these tests, there are a whole number of factors. Now, if I actually went into these factors, it's going to take a long time, which we may not have.
What's the test? Is there an additional test or just these 2 tests?
These are the main 2 tests.
Main 2 tests.
Yeah. Okay. However, I just want to add to Raj, because I've actually plowed through the whole plethora of cases in this space, and there are actually other considerations increase. Of course, fundamentally, it's the control test, but they're actually, if you look at major decisions, both at the High Court in Singapore, there are actually a lot of other factors which are taken into consideration. So I would say other factors that and circumstances.
So we have to bring our Q&A session to a close, and those were all the questions that we had. So we hope that everyone had a better insight as to their rights on workplace safety and work injuries, as well as the responsibilities that they may have to shoulder in various instances. So we're going to end this session, but if you have any workplace safety issues, and if you are an NTUC member, you're keen to register for a legal clinic session, you may write to this email address, which is lawworks, LAWWORKS, @ntuc.org.sg. And after this webinar ends, a feedback form will be shown in your browser for your completion. And we would really appreciate if you could just take a couple of minutes to complete it so we can improve our webinars moving forward. So thank you again, Raj and Patrick, for sharing your valuable insights. And thank you to you, our participants, for joining us today and for taking time off to listen to us. So have a great week ahead.
Thank you.
Thank you.